Social media informed me recently that I can no longer use the word lawyer to refer to myself. Because I'm licensed in 2 U.S. jurisdictions, I have to use the word attorney because, well, an attorney, they claim, is a person who is licensed to practice law and has passed a bar exam. They claim that the distinguishing factor between these two terms is simply bar passage and holding a law license. Is this much ado about nothing? Most of the social media videos I've seen on this subject appear to be from lawyers, a few from teachers.
What's the difference between a lawyer and an attorney? A lawyer is somebody who's graduated from law school and who has received a Juris Doctorate degree. However, an attorney not only has a Juris Doctorate degree, but they've also passed their attorney state bar exam and are licensed to practice law in that state.
Here's another example of a lawyer with extra rings, perhaps, to emphasize his point that lawyers have not passed the bar, but attorneys have.
Both lawyers and attorneys have graduated from law school, but in order to practice law and become an attorney, lawyers must pass the bar exam and become a member of a state bar association. In other words, all attorneys are lawyers, but not all lawyers are attorneys. You'll hear them say, hey, I've got you covered.
Even Indeed, a very well-known job board, wrote an article on the subject covering this same distinction.
So are some of the most elite law firms in the nation utterly clueless about their own terminology, especially on their public website?
Here are two law firms often ranked within the top 5 or 10 in the nation that use the term lawyer to refer to their professionals, who failed the bar, of course, and are making millions a year. No, by lawyers they mean their professional counselors, duly licensed to practice law in the relevant jurisdiction.
The notion that lawyers and attorneys are terms to be differentiated is completely invalid and unfounded. It's not supported by statutory or rule-based language throughout the U.S. that addresses lawyers and attorneys and members of state bars who are licensed to practice law.
Even Supreme Court cases use the term lawyer and attorney interchangeably to refer to someone who may represent clients because they are licensed to practice law. One older decision that used the term lawyer was Gideon v. Wainwright, which established a right to counsel, which is representation by a lawyer for indigent criminal defendants. Here's a more recent Supreme Court case that uses both the terms lawyer and attorney numerous times throughout, plainly meaning in both cases a person holding a law license who may represent clients.
In short, this whole distinction between lawyers and attorneys is really just an attempt to split hairs that really don't even exist. But here is one more reason why the term lawyer means a person holding a license to practice law.
All 50 U.S. states and the District of Columbia have adopted ethics rules that largely track the model rules of professional conduct drafted by the American Bar Association. Throughout these rules, the term lawyer is used exclusively, though the term attorney or counsel would also have worked, because these terms are, in fact, interchangeable.
Consider Ethics Rule 2.1. It states, in representing a client, a lawyer shall exercise independent judgment and render candid advice. And in rendering advice, a lawyer may refer not only to law but to other considerations like moral, economic, or social considerations. If a lawyer purportedly means a person who has graduated from law school but who has not passed the bar nor obtained a law license, then the ethics rules make no sense at all. What would be the point of ethics rules that apply to lawyers when they lack a license to practice law, represent clients, or render legal advice, which are the very core of the activities the ethics rules regulate? The American Bar Association is one of the largest organizations of lawyers in the world, and it's definitely the largest in the U.S. Not only does it promote ethical standards for practitioners by drafting ethics rules that have been adopted in all states, it also provides the highest level of accreditation in legal education, accrediting almost 200 law schools in the United States. Here you can see that the ABA uses the term lawyer and attorney interchangeably. I have to concede that at times one term is customarily preferred instead of the other. For example, the attorney-client privilege, which covers confidentiality of communications between a lawyer and a client for purposes of legal advice. But even though attorney is used far more frequently when dealing with this particular privilege, some states actually use the term lawyer-client privilege, like Florida does here. And here is a New York statute defining a lawyer in an educational code section as someone licensed to practice law. Plenty of other New York statutes use the term attorney. California is the same. Here is a statute from the Business and Professions Code that uses both terms in the same section to mean a person licensed to practice law.
The Department of Justice has a glossary online that uses both terms lawyer and attorney interchangeably throughout the glossary itself. Has the DOJ been kept in the dark, too, about the fact that lawyers can't practice law and don't hold a law license?
In short, the notion that lawyers have not passed the bar, but attorneys have, is misleading and simply wrong. A lawyer by any other name, an attorney, counsel, counselor, a member of a state bar that holds a license to practice law, is still just a lawyer.